How should the Constitution be interpreted? Should its interpretation depend on historical facts or present-day political desires?
The whole purpose of any constitution, and particularly the Constitution of the United States, is to remove as much as possible interpretation and application of the law from political controversy. You set up basic principles that are going to apply, and the legislatures and the courts have to abide by those principles. So if you're looking at standards, they are going to be historical legal standards as opposed to present-day political policies and desires. The Constitution has a method for dealing with political questions. It's called the amendment process. If it turns out that there are provisions of the Constitution that don't adequately address issues and problems that we've discovered today, then you go into that process. It requires a supermajority, 3/4 of the states, but that's to make the process really responsible to the desires of the population. We really want to know what the whole country, in essence, believes should be done, and not what a simple majority of one legislature may believe should be done.
What is the doctrine of original intent as it relates to interpretation of the Constitution?
The doctrine of original intent takes us back to the meaning of the Constitution as it should have been understood by a reasonably intelligent person in the late 1700s who was conversant, of course, with the English language, the words and phrases that appear, but who was also conversant with the law of the time, recent history, political traditions, and so forth and so on, because so much of the Constitution requires that kind of historical background to understand what the terminology means. We're not talking, though, about what any particular individual may have meant. So it's not what Thomas Jefferson may have meant, it's not what James Madison may have meant, it's not what Alexander Hamilton may have meant. I mentioned those three because they pretty much encompass the spectrum of political thought in the time. Jefferson being what we would call libertarian, Hamilton being what we would call a centralizer, a central government man, and Madison kind of in the middle, shifting from one position to another depending on the interests, his particular interests at the time. So we wouldn't look to something that Jefferson specifically wrote or Hamilton specifically wrote. We're not looking for a subjective interpretation. We're looking for an objective interpretation. What would any reasoning person would have understood this law to mean at that time? And that's very similar to what the law has understood in the area of contracts for hundreds and hundreds of years, called the objective interpretation of contracts. What does this document say? What does it say to the person who's reading it, not necessarily the person who wrote it? Now that includes, there's another element to that. It's not only that we're looking for the original meaning, but there's a fixity of meaning. The original meaning thereafter does not change. What it meant in 1789 is what it means today. And there are essentially two reasons why that has to be true. Number one, I don't think you can imagine a reasonable person entering into an agreement, which the Constitution really is, a large-scale political agreement of such consequence, and not knowing how that document might be changed and interpreted in the future. No one would leave himself in that kind of open-ended position. Secondly, the Constitution has a provision for amending itself, Article 5, a very detailed provision. And there's a very old doctrine in Anglo-American law, which in one expression is expressio unius exclusio alterius. The expression of one way of doing things is to exclude every other way of doing things. So the very fact that the Constitution has a provision for amending itself tells us that's the way it's supposed to be done, as a matter of what? The original intent, because that's what it says.
What is the doctrine of the living Constitution?
Well, the doctrine of the living Constitution is actually the opposite of original intent. It says that the Constitution changes its meaning in some automatic fashion according to the political or economic or social problems of the times. Now, there are really three, I call them apologies or rationalizations for this thing. And the first one is, well, we don't really know in some cases what was the original intent. But if that's the case, then that provision that we can't interpret is not a law at all. I mean, imagine if the Constitution is laid in front of you and right in the middle are some hieroglyphics that nobody can understand. Does that mean the Supreme Court or Congress or a state legislature can fill that in? No, there's nothing there. It's void. It's just out because we can't interpret it. The second doctrine says, well, we knew what it meant in 1789, but the definitions of words change over time. The language is a living entity, as it were. Now, that may be true, but you can't imagine people in 1789 writing a constitution and trying to foresee how language might change, right? They wouldn't have known how it would change. So yes, the language may change, but the original meaning of this document doesn't change. We have to use the definitions that were used at that time. The third explanation or rationalization is probably the most blatant one. It simply says, well, okay, we knew what it meant, and the particular language hasn't changed significantly, but it really doesn't do what we want it to do anymore. We have problems that the Founding Fathers didn't foresee, and we're simply going to interpret it in a different way. That's either Congress could pass a statute, or more likely the Supreme Court, in writing a decision, can come up with some new interpretation. And the short answer to that is, well, that makes either Congress or the Supreme Court the amending body. They're the ones who determine, as a result of their political wisdom, what needs to be changed, not the people, according to the amending process in the Constitution. And we already have found out that the amending process in the Constitution is the sole methodology that's given to us. So this new interpretation of the living Constitution, I think, as I call it, the most blatant one, really is an attempt to override the most obvious provision in the Constitution relating to that subject, Article 5. And as a result, it couldn't possibly be correct. But it's the one that's used for the simple reason that the Constitution is difficult to amend. And so politically, people are constantly frustrated. They want to do something. They can't get enough of the country to agree with them. And the living Constitution is a way, in a sense, essentially to run around the Constitution. But fundamentally, it's a dishonest way, because the whole purpose of the amending process is to be sure that you have a real national consensus, not simply the political proclivities of the people that happen to be in Congress or the people that happen to be in the Supreme Court.